Good afternoon. I'm delighted to be speaking with you today for 18 minutes. I wanted to make sure to get that there to remind myself, and we've got help from the back as well. Like the judge, I had lunch on my mind today. It is a tough act to follow. People start to drift off, as this candid picture of my own afternoon law students will attest. I tried to figure out what might be relevant, and you may have seen me in the back here constantly reworking the lecture as I heard the other people going. I found I already knew how difficult it was to try to write things in this area after Professor Morse. Now I'm faced with having to speak about these things after he spoke of them, as well as our other fine panelists. And I was trying to figure out, how will I style my remarks? What hat will I wear of the different things that they've described in order to add something, to add anything at all? You know, which hat should I wear? And I eventually decided this would be the hat. You know, it suits me, it has historical relevance, but it's to wear the war hat, to talk about these things from the perspective of the trenches. You know, those of us who actually have to go in there and, as so-called experts, sell the opinions and work with the attorneys who liked what it is that we had to say on the basis of our evaluations in civil and criminal cases, and actually try to bring it forth. So when we look first at the civil area, I was looking for a blind justice for a picture here, and I thought this one from the Colorado NRA was the pick of the litter. We're talking here about substituted judgment. We're talking in a civil arena when it comes to capacity about replacing some individual's judgment with that of another person or an agency, and we can look at this really in three different time frames. Substitutions for prior judgment. The person being evaluated made a decision in the past. Are we going to second guess that? Do we think that that old decision wasn't any good? Substitutions for present judgment. They're making a decision now. What do we think of it? Or substitutions for future judgment. Are we going to step in and limit this individual's freedom to make certain choices on his or her own? Well, when we talk about substitutions for prior judgment, we're talking about reaching into the past and seeing what sort of decision was made formally and deciding what we really think of it. Well, how about testamentary capacity? There's a pretty good example of that. Now, we can cheat a little bit, actually, in these exams. Often this is done by way of what we call a psychological autopsy, where we go back over all of the records and we interview people and try to figure out what it is that the person did in the past. And I don't know all that much about brain scans, but I'm willing to believe that once the person is deceased for a certain period of time, you can additionally substantiate their passing on the basis of the brain scan, and things just really, Judy's nodding, so I know I'm on the right track. She's a real doctor. But you can also actually get in there ahead of time, get in on the ground floor, as it were, and try to evaluate their testamentary capacity based on what they're about to do. And a lot of lawyers in the room, we won't spend all day on this, but you got to know that you're making a will. You've got to know what it is that you're planning on giving away. You've got to know how it is that you're planning on doing it. And you also have to know, in that great old phrase, the natural objects of one's bounty. Who is it that you would be expected to give this stuff to, if you can pardon the use of prepositions? So how do we get at all of this, and where is the decision making here? Well, you've got to know what you have, and then in particular that disposition is going to be important. You've got to make some decisions about who gets what. Well, and here's the great book on psychological evaluations for the courts, of which Chris is a co-author. You're looking at what their conception is of a will. What are they trying to do? Why are they making a will at this point? You're trying to figure out if they understand what they've got. You know, what is it that they did for a living? What sort of money do they have? What sort of money did they make? And then critically, what are the general consequences of what they're going to do with all of this money or property? How is this going to affect people? How is this supposed to happen? And who are the persons whom the decisions will be affecting? How do we look at this? Well, there are a bunch of different things that are important and relevant to the scanning. There is the notion of organic brain dysfunction, in addition to the way in which these other concepts here are going to be affected. I see this in the future as something that would be highly relevant, and I personally can't wait to be able to refer to the scan folks in more of these cases when, and you'll see this as a recurring theme, the science appears to have caught up. Now, how is it that we're going to actually conduct all of these examinations? By having that decision-making demonstrated. We're going to ask them, how is it that you would make that decision? Make some other decisions for us. Substitutions for present judgment, an example there would be competence to consent to treatment. And we do have a test that looks at decision-making, a test to which some of the people in this room contributed advice, the MacArthur Competence Assessment Tool for Treatment. And come to think of it, MacArthur, I think we know where the money came from for that as well, in large part. Now, when we look at substitutions for future judgment, we can be looking in particular at guardianship, because guardianship tends to pull together so many of these different civil competencies. And hot off the presses, I discovered this on the way to come and do this lecture. The new issue of the American Psychologist has an article by Jennifer Moy, Dan Marson, and Barry Edelstein, the holy trinity of guardianship research, assessment of capacity in an aging society. And I was anxious to think that, you know, with 18 whole minutes to fill, they might be able to give me something that could help pad this out. And I wasn't disappointed. They talked about the sorts of stuff that we psychologists do all the time, clinical interviews and forensic assessment instruments. But they also, and here's where I got excited, they talked about advancing capacity assessment for the next generation. In this final section, we anticipate future developments for this still young field. And then I was a little more disappointed at the end when they said we see these things, 6 major directions for the field of capacity assessment of older adults for the next 20 years. A lot of people in this room really don't want to wait that long, and I've seen in some of our discussions, there are a few long faces already. I would direct our colleagues to the name of the conference, The Future of Law and Neuroscience. It seems from what I've been hearing this morning that we're not there yet. They say that it holds substantial promise, and indeed it does. And they talk about how improving understanding of these relationships may provide important information to integrate. I think inevitably it will. One of the particular areas of promise, I think, in this area, one where you'll be able to make an impact sooner rather than later, would be in cases of dementia. When guardianship problems are based upon this deterioration of the brain, I would think that brain science is more likely to register a positive effect with the people with whom I'm working in that particular area. What about on the criminal side? Competency to stand trial. I think most of the people in this room know what we're talking about here. You're talking about the defendant's mental capacity at the time of the trial. It focuses on the ability to understand that trial process. It doesn't relate to culpability for the offense itself, and it has a decision-making component when we look specifically at whether somebody has the capacity to assist in his or her own defense. Can they consult with their attorney? Can they confront witnesses? Can they testify? Can they make decisions as the not just nominal but actual head of the defense team? And can they communicate this information effectively to counsel? Well, what do we do in order to figure out whether someone is or is not competent to stand trial? We conduct our cognitive assessments, and we go in and we'll do intelligence testing, and we'll do neuropsychological screening or full-on neuropsychological testing composed of batteries of all of these different measures. And we will also critically, you just cannot, in this day and age, do a forensic psychological evaluation without at least attempting to administer tests for malingering. You just have to do it. And the same thing with personality assessment. There are measures to see if someone is malingering a psychotic or other relevant psychiatric condition. And we have various personality tests to do that. It would take even more than 18 minutes, I think, to catalog what those different types of tests are. And then we do the clinical interview. And once again, in this portion of the evaluation, if there's decision-making to be done, we want you to demonstrate it. Show us how it is that you make decisions. Now, it may be that eventually scanning will be able to demonstrate in real time how decisions are being made. Already, to my limited understanding, you can sit there and watch different parts of the brain communicate with each other in different ways. We're getting there. Are we there yet? It doesn't appear that we're there yet. Are we headed there? Absolutely. There is a forensic test. There are actually many, but one of more recent vintage, and again, with a nod to our hosts, the MacArthur Competence Assessment Tool for Criminal Adjudication. One area, I think, in which you'll be able to register earlier than most, based on the work that I see being done with the attorneys, is in the area of substance abuse. You'll be able to establish, I think, there more effectively than in some other areas what the effects are, to show the differential results based on the type and amount of substance abuse and dependence that have been identified. Now, I want to tell you of a situation that I had that I think speaks to a lot of the discussion I've heard so far today, from up here on the stand, but also amongst audience members. I was, and still am, conducting an evaluation in an unnamed southern state. In fact, I told them, I'm just the consultant, but I think if you guys actually go get a name, that's going to make a difference. That'll really put you literally on the map. And it was, and is, an arson case. And what it revolves around is Miranda. I went and I evaluated the examinee. This was a young fellow who was working as a firefighter and who was accused of setting fires. Now, a lot of us, especially the clinicians in the room, are already thinking about certain diagnoses that might make sense there. But the real issue was the statement that this fellow gave. Well, I went and I did the cognitive testing, and I found with the cognitive testing that there were some problems. Dug a little deeper neuropsychologically. This person, from a paper and pencil test perspective, seems to be misfiring in a lot of interesting ways. And okay, and I went ahead and did the intellectual testing, and I found that his verbal facility, his ability to understand spoken and written words, was a lot better than his ability to use various types of abstract reasoning. So I called up counsel and let him know, all right, I did all of this stuff, and in my opinion, this is someone who ought to be referred for a neurological evaluation. And I kind of let that sink in for a second, Great. And he said, well, what would that do for me? And I thought that was a very good question, and I tried to answer it as best I could. I'm an attorney, but you always avoid the lure of trying to practice the case of the attorney who hires you whenever you're the expert. I said, well, I don't know. In other cases, I've found that counsel has been able to do quite a bit with actually showing what is physically wrong with the brain of the defendant and how that brain works. But, and he said, yeah, I hear you, and I've had cases like that too. But in this particular matter, have you demonstrated to your own satisfaction that this person has neuropsychological problems? Yes, I have. And did you go and do a forensic evaluation after that and do the interview? Yes, I did. And I went over the transcript. And there's a lot of stuff that this individual just doesn't get. He said, well, you know what? That'll do it. That's okay. We could spend all this money, and then what happens when I do my scan and it comes back and it didn't help? That was one particular case at this particular point in the history of neuroscience and law. In order to have this move beyond what some attorneys would think is merely window dressing, it's going to have to move forward from just being able to show why it is that somebody has a problem, moving beyond causality to how things are working now, and to really make that stick from a legal perspective. And it's also going to have to move forward in order to show how it is that somebody is likely to be able to function in the future. This isn't a criticism of neuroscience and the law. I think it helps to illustrate where I think just about everybody in this room agrees that it will be going. Because we have to be able to get, for instance, in criminal cases, for attorneys to find this useful at the particular elements of whatever crime that a defense or a prosecution is being fashioned to address. We heard earlier about the Drogin case. And here's an individual who was alleged to be psychopathic. The question's going to be, all right, now we can show from a brain science perspective what that means, but we always want to try to figure out what that also means for counsel, prosecutor or defense attorney in trying to deal with this. Because what attorneys want to do is to win cases. Ask any of them. I mean, look around today and ask them what they want the outcome to be. They want to prevail over the other side, as they should. That's why we hire them. So what sorts of weapons can we fashion for counsel so that he or she can prevail using these measures? Now, that doesn't mean you're going to prostitute your science to the desires of the legal profession, civil or criminal attorneys, but you're always thinking when you develop this material, how relevant is it going to be in a legal context? Will medicine need to race to catch up? Sure, and so also will the law. And again, what we're looking at today is the future of neuroscience, and I can't think of a better place from what I've seen and heard today for this sort of discussion to get kicked into a higher gear. Might even have a minute left, but I'm sure somebody else will make good use of it. Appreciate the opportunity to speak with you.